Who's excited? Who's excited for some mock trial? All right. Good afternoon, everyone, and welcome to the championship round of the 2023 Windy City Challenge. It is hard to believe that we are here after 4 really intense, incredible rounds of competition. Teams, I know there's some nerves, so before we call on the judge, I want everyone to breathe in and just look around and realize that there are only 2 teams that are here right now in this room. You are the champions of your divisions. And no matter what happens today, you should always remember that. You should be incredibly proud of yourselves. I know your coaches are proud of you. And really during this round, as you get nervous, try to keep that perspective and enjoy this moment, enjoy this experience. The Honorable Judge James Shapiro of Cook County Circuit Court will be presiding over this trial. He will be joined by 15 jurors. All 15 of their ballots will count for the eventual result. When I knock, please rise. Judge Shapiro will come in, and then I will ask the judge when I can invite the jury in. Best of luck, y'all. Have fun. Yeah. Imperial District Court is now in session. Honorable James Shapiro is presiding.
Please be seated.
Judge, may we bring in the jury?
Okay. Good afternoon, ladies and gentlemen of the jury. Please be seated, make yourself comfortable. The court will come to order and call the case of Justice Carbo versus Shooting Star Gun Club, LLC, case number 23CV002023. The court will first hear argument and decide the plaintiff's pending motion in limine regarding the claim under the Responsible Firearm Sales Practices Act. Will counsel for Justice Carbo stand and state your appearance?
Good afternoon, Your Honor. My name is Jazz O'Broy, and today I'm joined by my co-counsel, Mr. George Ma. Good afternoon, Your Honor.
Good afternoon, Mr. Ma, Mr. Broy.
Mr. Kabir Mateo. Good afternoon, Your Honor.
Mr. Mateo.
And Mr. Kenny Royer. Good afternoon, Your Honor.
Good afternoon, Mr. Royer. Thank you.
Today we represent the plaintiff, Mr. Justice Carbo.
Thank you. Will counsel for Shooting Star Gun Club please stand and state your appearance?
Good afternoon, Your Honor, and members of the jury. My name is Daniela Dibble, and today I will be representing my client, Shooting Star Gun Club, in the pretrial motion.
Good afternoon.
Good afternoon, Your Honor, and members of the jury. My name is Mary Callie, and together with Philip Davis.
Good afternoon, Your Honor, and members of the jury.
And Haley Tack. Good afternoon, Your Honor, and members of the jury. We will be representing our client, Shooting Star Gun Club, in today's proceeding.
Thank you, Ms. Kelly. The court will briefly remind the parties of the procedure for argument. The parties will each have a total of 8 minutes to present argument, with the possibility of up to an additional 2 minutes in court courtesy time that the court may permit in its discretion. Counsel will each have 45 seconds to present your argument without interruption, after which the court may ask questions. Counsel for Carbo will argue first as the moving party. The jury is constructively absent for this argument, so counsel should address the court only. Mr. Breuer, is it? I'm sorry, Mr. Breuer, are you ready?
Your Honor, Mr. Kavneer Mattel will be doing the pretrial argument.
Mr. Mateo, okay, very good. All right, Mr. Mateo, you may present your argument.
Yes, Your Honor. Before I begin, may I reserve 3 minutes for a rebuttal?
You may.
Thank you.
Timekeepers, please reserve 3 minutes for Mr. Mateo's rebuttal. Thank you.
Good afternoon, Your Honor. Kavneer Majel on behalf of the plaintiff, Mr. Justice Carbo. May it please the court. The issue before the court is whether Section 2007 of Imperial Civil Code, which creates civil liability for the reckless entrustment of a gun to an unfit individual, violates the Second Amendment. It does not. My client, Mr. Justice Carbo, was severely injured at the defendant's shooting range by an employee entrusted with a gun. Our second cause of action in this lawsuit arises from this statute. For these reasons, the court should grant the plaintiff's motion in limine and allow Mr. Carbo's statutory claim to reckless entrustment to proceed to trial for 2 reasons. First, the Second Amendment does not apply to this statute because the statute does not infringe on individuals' rights to keep and bear arms. And secondly, even if the Second Amendment did apply, the statute follows historical restrictions on gun use.
If it doesn't interfere with individual rights, does it interfere with collective rights, as the Second Amendment at one point was understood?
Your Honor, as the court established in Heller, the Second Amendment only applies to law-abiding citizens, which means that collective rights are not protected by the Second Amendment, and the plain text of the Second Amendment protects law-abiding citizens' rights, which means individuals.
Well, the plain text of the Second Amendment doesn't really say anything about law-abiding citizens. It just says the right of the people to bear arms shall not be infringed, right?
Yes, Your Honor. The court established in Heller that phrase being used by the terminology of the time the Constitution was written, that phrase refers to individuals.
Make it continue.
Yes, Your Honor. And I'll take each point separately. First, the Second Amendment does not apply to this statute because this statute places civil liability on firearm companies' ability to sell arms. That does not infringe on individuals' right to keep and bear arms because to keep and bear arms does not require for a sale to take place. And we'd also like to inform the court that the plaintiff will only be pursuing claims for the entrustment of a gun to Drew Cantrell, which means that the constitutionality of the sale aspect of the statute is not in question in today's pretrial argument.
So you're distinguishing the sale of arms from the right to keep and bear arms then?
Yes, Your Honor.
I mean, isn't that sort of a distinction without a difference?
No, Your Honor. As the court established in Heller, the plain text of the Second Amendment excludes secret and technical meanings. The plain text of the Second Amendment does not protect the ability to sell arms. It simply protects the right to keep and bear arms, which the court established means carrying with a purpose, which does not mean to sell them.
I mean, were there no arms sales back in colonial times when the Second Amendment was passed, or post-colonial times, I guess? I mean, muskets were bought and sold, weren't they?
Yes, sir. And the court established that commercial regulation still applies. However, it does not infringe on the plain text of the Second Amendment. The Imperial statute in question does not infringe on individuals' rights to keep and bear arms. It does not protect companies who sell firearms either. So those in colonial times who would have sold muskets. And even if the Second Amendment does apply, the statute follows a historical analog of similar gun restrictions. As the court established in Brune, may issue statutes, those that require discretionary criteria and allow state individuals to determine the eligibility or suitability of one to possess a gun, are analogous to the statute in question, which by the 2-part test established by Justice Thomas in his opinion in Brune, that means it is constitutional under the Second Amendment.
Do McDonald and Heller survive Brune?
Yes, Your Honor. Some portions of the precedent set in McDonald and Heller were struck down in Bruin, but the majority of those opinions are still precedent.
Thank you.
For those reasons, Your Honor, the plaintiff requests that the court grant its motion in line.
Thank you, counsel. Okay. The counsel for Shooting Star,
Yes, Your Honor.
okay, you may argue.
The defense opposes the plaintiff's motion to bring into action statute 2007 as it is unconstitutional under the Second Amendment. I first want to address a misconstruction on behalf of the plaintiff. They said that statute 2007 does not impede upon the right of the individual to own guns. Your Honor, that's not true. By restricting the seller's ability to sell and entrust others with guns, that is directly stomping on an individual's right to own arms. Now, we look to the case of New York State Pistol and Rifle Association v. Bruin to determine the constitutionality of this standard. It holds that the government must prove that this regulation is historically consistent with this nation's historical tradition of firearm regulation. Now, today, the plaintiff takes on the shoes of the government as they are presenting this regulation. And in searching for the historical analog of statute 2007, we find that it is most similar, as the opposing counsel pointed out, to the May issue laws that were held unconstitutional in Bruin.
I mean, these are just laws relating to the sale of a gun, right? I mean, how do those infringe an individual's right to keep and bear arms? I mean, this is just to say, why can't you regulate the sale of a gun, or who sells guns, the training required and supervision required for someone who owns guns? Well, how is that inconsistent with the Bruin case?
Your Honor, sorry, can I receive some clarity on your question? What exactly are you asking?
Sure. How does regulating the sale of a gun, how does that interfere with the Second Amendment?
Your Honor, every individual has the right to keep and bear arms, and they only receive that right by the sale of guns. How else are they supposed to receive these guns?
I understand, but if you regulate how they receive the guns, I mean, why isn't that analogous to a reasonable time, place, or manner restriction under the First Amendment, the immediately preceding amendment?
Your Honor, we have no contention with gun restrictions in general. We just have contention with this specific gun restriction as it far exceeds the shall issue laws the court deemed constitutional, in which threshold requirements had to be met by the seller. Now, when we look at statute 2007, it is very different. Statute 2007 operates on the totality of the circumstances, which means based on different circumstances such as mental stability, criminal history, and this is among 9 factors listed in that standard. Whether or not a reasonable person, which is not defined by this standard, would have the ability to determine an individual's fitness in regard to guns. And as Justice Kavanaugh points out, this is constitutionally problematic since it is a May issue law. Now, to quote Bruin exactly, a May issue law is when authorities have discretion to deny licenses even when the applicant satisfies the statutory criteria, which is constitutionally problematic because it grants open-ended discretion to licensing officials, which in effect denies the right to carry guns from ordinary citizens.
But it doesn't necessarily deny the right entirely. I mean, it just regulates that right to sell the firearm, doesn't it?
Your Honor, we respectfully disagree. In this case, as it is an as-applied law, we believe as the Shooting Star Gun Club that this is an unfair burden on the Shooting Star Gun Club and that Drew Cantrell was qualified to own the gun, yet Shooting Star Gun Club is being held accountable for a vague set of criteria. And when we look further into statute 2007, since it is based on the totality of the circumstances, we expect some balancing regime with these circumstances. However, it gives us no standard as to how to balance these circumstances or what acts would impede upon these circumstances and bar an individual from obtaining a gun. It's entirely up to a seller, which is an unfair burden, Your Honor.
What exactly are you asking this court to do?
To reject statute 2007 as it is far too ambiguous and a seller should not be held to that standard.
Is there a proposal? Do you have a proposal how it could be less ambiguous? Is there a model statute that would pass muster?
Yes, Your Honor. If we look to the case of Bruin in general, it differentiates between shall issue laws, may issue laws, and proper cause laws. And it holds that shall issue laws are constitutional and they're held in 43 states across the United States because they just have those threshold requirements, which are easy for the seller to determine an individual's fitness in regard to guns. Today's statute is far different in contrast to that. It is like a may issue law because it requires unfair discretion from the seller to determine an individual's fitness in regards to guns.
I mean, so your challenge is an as applied challenge or a facial challenge then?
As applied, Your
No, I mean, how do we know? I mean, is that issue ripe for adjudication now? How do we know that it's improperly applied in this case?
Yes, Your Honor, it is our contention today that Shooting Star Gun Club is being held to the statute, which is unreasonable because Drew Cantrell was a qualified employee, yet they're being held by criteria with no bounds.
But isn't that to be decided? Isn't that an issue to be decided by the jury?
Yeah, but the problem is, Your Honor, this statute, it doesn't give us any criteria to the jury as to how to qualify Shooting Star Gun Club as negligent in their entrustment to Drew Cantrell.
So your claim is that it's simply too vague then?
Yes, Your Honor, as we look to binding precedent, this statute is far too vague and would be looked down upon by the cases of U.S. v. Heller and Bruin.
Your position is you agree with your opponent that Heller survives Bruin?
Your Honor, are you asking me if Heller?
If Heller, if anything, if Heller and McDonald survive Bruin, I'll ask you the same question that I asked your opposing counsel. That Heller, you feel that Heller and McDonald survive the Bruin case?
Well, Your Honor, as Bruin points out, we can't rely too heavily on this historical analog itself because times have changed, because gun regulations have changed. And so that's why it clarifies this shall issue, may issue, and proper cause laws, as those are more relevant to our case in today's court.
I mean, how far back are we supposed to go under originalism analysis? They had musketry in originalism. They didn't have machine guns. So, I mean, how can we regulate machine guns under the Bruin case? Because that wasn't a traditional restriction, right?
Well, Your Honor, as Bruin was only decided a year ago, does take these considerations or does take these factors into consideration, which was why it puts different restrictions in these boxes for us to clearly determine which ones the court is okay with and which ones would be unconstitutional and impede upon an individual's right to self-defense, which is why we move to, why we disagree with the plaintiff's motion and ask that you deny it.
Thank you,
Thank
counsel.
you.
Counsel, rebuttal?
Yes, Your Honor. I'd like to address an issue that opposing counsel brings up in her pretrial argument. She said that Bruin's established that may issue statutes are unconstitutional. This is objectively the wrong precedent that Bruin set. Bruin simply struck down New York's outlier may issue statute, but remained 6 other may issue statutes in states like Delaware, Connecticut, and Rhode Island to be constitutional. Those may issue statutes that exist now provide a historical analog of similar statutes with discretionary criteria that make this statute constitutional.
But isn't this statute closer to the statute that was struck down in Bruin rather than the other state statutes?
No, Your Honor. As Justice Kavanaugh wrote in his concurring opinion, the other states could have may issue statutes as long as those states employ objective licensing requirements. The Imperion statute in question employs history of military experience, history of drug and alcohol experience, mental health diagnoses, his affiliation with terror groups. These are all objective criteria that can be used to determine the fitness of someone to own a gun.
We're going to entrust that analysis to an individual firearms dealer?
Yes, Your Honor. The May issue statutes establish that discretionary criteria can be used to allow for gun regulation on individual sellers.
What about your opponent's argument that it's simply too vague, that the standards are just too broad for an individual to apply those standards?
There are several objective licensing standards that make this a very an objective statute. Things like history of drug and alcohol abuse, mental health diagnoses, affiliations with terror groups, all of which are objective standards to determine the fitness of someone to own a gun. And I'd also like to bring up that the sale of the constitutionality of the regulation of a sale of a gun is not a question in today's pre-trial argument. Rather, whether or not the entrustment of a gun to Drew Cantrell and the removal of that entrustment violates Drew Cantrell's Second Amendment rights. It does not. The question before the court should be that if Drew Cantrell had not been entrusted with a gun, would Drew Cantrell's constitutional rights been violated? The answer is no, because Drew Cantrell could have bought a gun from another store, and Drew Cantrell could have bought another gun from another store and still had the right to keep and bear arms. For those reasons, Your Honor, the plaintiff requests that you grant our motion in limine and allow Mr. Carbo's statutory claim to proceed to trial.
Thank you, counsel. Okay. It's not the responsibility of the trial court to not follow. It is the responsibility of the trial court to follow the law. I may or may not disagree with the Supreme Court's holding in Bruin, but I think this statute, frankly, does violate the Supreme Court's holding in Bruin. As much as I may disagree with that holding, I have to follow it as a trial judge. I'm bound to do so. So I'm going to deny Plaintiff Carbo's motion in limine. Okay, timekeepers for Carbo, are you present and ready to proceed?
Yes.
Okay. And timekeeper for Shooting Star, are you present and ready to proceed?
Yes.
Thank you. Okay, we're now ready to begin this trial. I'll give the parties an opportunity to handle some brief housekeeping matters. I'll start with counsel for Justice Carbo.
Yes, there are some brief housekeeping matters. Permission to hand, Your Honor, the character evidence form signed by both counsels prior to trial.
Permission granted.
May we have permission to move freely about the well during speeches and examinations?
You may, and you don't even need to ask the court permission to approach a witness. You may just do so without requesting. That'll save some time. Okay, so your permission to move about the well of the courtroom, about the entire courtroom, including behind the jury box, if you so desire, on direct examination. Hint, hint. Will be granted. You can use the courtroom as your stage. Any other housekeeping matters from the plaintiff?
No, Your Honor.
Okay, from the defense?
Yes, Your Honor. First of all, we would like to ask that our party representative be able to rearrange and sit at our council table.
Yeah, any objection to that?
No objection, Your Honor.
Okay. Your party representative for Shooting Star may certainly sit at the council table. Absolutely.
Thank you, Your
They have
Honor.
right to do that in both civil and criminal cases. Absolutely. In civil cases, they have a right not to be there if they so choose, but they have a right to be there if they so desire. Anything
Yes.
else?
Yes, Your Honor. We'd like to make the court aware of stipulation 13, which states that Jackie Staub is an expert in firearms mechanics.
Okay, any objection to that? So stipulated, counsel, I should say? So stipulated?
No objection, Your Honor.
Okay, all right. So stipulated then. That stipulation will be in effect.
Your Honor, we'd also like to make the court aware that all witnesses are constructively sequestered, which means they cannot testify to what they hear in court today, excluding the party representative.
Yeah, I've heard that, that term before in the first round, actually sequestered. Usually we sequester juries. We may sequester this jury, in this jurisdiction at least. I don't know about Empyrean, but we usually call it exclude, a motion to exclude witnesses rather than sequester witnesses, but I get the same thing. It's the same difference. And so witnesses don't hear the testimony of other witnesses, and their testimony isn't influenced by that. No objection to the motion to seclude or to exclude or sequester, constructively seclude or exclude or sequester the witnesses, right, counsel?
Yes, Your Honor.
Okay, so no objection?
Correct.
Okay, all right, that motion will be granted.
We'd also like to ask if we can place an exhibit packet on the witness stand, as opposing counsel has already agreed that these are fair and accurate representations of those exhibits.
Any objection to that?
No objection, Your Honor.
Okay, you may do so then.
Give those exhibits as well, that way you can reference them during the trial.
That would help. Thank you.
Permission to approach the bench.
Yes.
You're welcome.
Any other housekeeping matters?
Yes, Your Honor, we'd just like to ask if we can publish exhibits to the jury with referencing them as long as they are already admitted.
Any objection to automatic publication to the jury?
No objection, Your Honor.
Okay, and that'll go for you too, of course.
Yes, Your Honor.
Okay, yeah, you may do so.
At this time, we are ready to proceed.
Okay, excellent. Before we begin, I'd like to let both parties know that I will take a moment after each statement or examination to ensure our judges have been able to submit their scores and comments into the tabulation software, okay?
Yes.
All right. All right, counsel for Justice Carbo, you may begin your opening statement.
Yes, Your Honor. May it please the court, opposing counsel, and members of the jury. The signs were there. It's May of 2021, inside a local gun store. The store's owner walks out of the back room to discover a terrifying scene. Someone aiming a gun at one of his employees. But the store wasn't being robbed or held up. The person aiming the gun was also an employee. A sales clerk in a heated argument with one of his coworkers. Now, luckily, the store's owner was able to calm everyone down and nobody was hurt that day. But instead of firing the employee, or even sending the employee home, the store's owner promoted the employee. Evidence will show that within 3 months of violating the most basic rule of gun safety, the defendant, Shooting Star LLC, promoted that employee, Drew Cantrell, to firearm safety instructor, placing a gun in her hands every day. You'll learn that after this shocking promotion, the mistakes continued. The employee continued to handle guns unsafely. And finally, in May of 2022, the inevitable happened. Someone got hurt. And that someone is my client, Mr. Justice Carbo. Mr. Carbo had seen a commercial on TV that said Shooting Star was the experts. That if he visited the defendant's store, it'd be like learning acting from Meryl Streep or basketball from Michael Jordan. But instead, the defendant assigned Drew Cantrell to teach Mr. Carbo's class. And evidence will show that Drew Cantrell mishandled a Glock 22 and shot my client in the leg. which is why Mr. Carville filed this lawsuit against the defendant for negligent hiring and retention. Because the defendant knew that Drew Cantrell was unfit to be a firearm safety instructor. Because the signs were there. Good afternoon, members of the jury. My name is Jessica Oberoi, and I, along with my co-counsel, represent Mr. Justice Carville. Today, it is our burden to prove to you that it is more likely true than not that the defendant, Shooting Star LLC, hired and retained Drew Cantrell despite the fact he was unfit, and that Ms. Cantrell's employment caused Mr. Carville's injury. We will meet this burden by proving 3 facts. Fact number 1, Drew Cantrell was unfit to be a firearm safety instructor. Fact number 2, the defendant knew that. And fact number 3, the defendant still put a gun in the hands of Ms. Cantrell to teach Mr. Carville's class. So let's take those one at a time. Fact number 1, Drew Cantrell was unfit. You'll learn a lot about Drew Cantrell during this trial, about a pattern of poor decision-making. You'll learn that she intentionally aimed a gun at another employee, that she violated basic gun safety rules time and time again, and that she had a criminal record with reckless conduct. So you might be wondering, well, she must have had a lot of experience as a firearm safety instructor if the defendant got past all that. But no. You'll learn that the very first time Ms. Cantrell worked as a firearm safety instructor was when the defendant promoted her. An expert in gun safety will testify that in his professional opinion, Drew Cantrell was unfit to be a firearm safety instructor. Fact number 2, the defendant knew that Drew Cantrell was unfit to be a firearm safety instructor. An eyewitness named Ross Hernandez will testify that he was present in the defendant's store when Drew Cantrell aimed a gun at another employee. But the most important thing you'll learn from Mr. Hernandez is not that the incident happened, but that the defendant's owner was also present in the store when it happened and saw the incident with his own eyes. You'll also learn that the defendant's owner knew or should have known about Ms. Cantrell's lengthy criminal record. And finally, the third fact. The defendant still put a gun in the hands of Ms. Cantrell to teach Mr. Carville. Now, this fact will be undisputed. But the real question is why? Why did the defendant still put a gun in the hands of Ms. Cantrell despite all the signs? The answer is money. You'll hear testimony that the defendant's owner admitted under oath that Drew Cantrell's promotion was, quote, good on the checkbook. All of this is why, at the end of the trial, my co-counsel, Kenny Royer, will ask you to find the defendant liable for reckless entrustment of a fire, for negligent hiring and retention of an employee, because the signs were there. Thank you.
Thank you, counsel. Counsel for Shooting Star Gun Club, you may proceed when ready.
Yes.
You may.
Harbo knew the risks. In Imperial, crime runs rampant. Cars are broken into, people are robbed, you don't feel safe anymore. You think that you need to protect yourself, protect your family. So you go to your local gun store. Because desperate times call for desperate measures. You go to your local gun store, the first thing you see are big signs that read gun safety rules. Because guns are dangerous. You go and sign up for a gun safety training course because you know that guns are dangerous. Before you're even allowed to take this course, you're given a liability waiver to read and sign, telling you just how dangerous guns are. Members of the jury, this all happened on May 28th, 2022. To appear on citizen Justice Carter when he went to his local gun store, the Shooting Star. Unfortunately, during his safety lesson, he was shot in the leg. It's a terrible situation, but the evidence will show that Carbo knew the risks of it. Now, the plaintiff has brought a claim of negligence against my client for the retention of Drew Cantrell, the instructor who gave the safety lesson. With this claim, they carry a burden. It was proved to you today with a preponderance of the evidence. One, Drew Cantrell was an incompetent instructor. Two, Shooting Star owner Skylar Coleman knew of this incompetence. Three, Drew Cantrell caused Justice Carbo to suffer serious injuries. Members of the jury, they will fail to meet their burden today. Instead, we have brought to you what's called an affirmative defense. We've taken on a burden ourselves to prove to you that it's more likely than not that Justice Carbo, one, knew the risk of injury, and two, voluntarily proceeded anyway, making him liable, not my client. Now let's take these one by one. First, Carbo knew the risk of injury. Members of the jury, you'll hear from Justice Carbo himself. He'll tell you how he knew guns are dangerous, especially to those who use them. You'll hear how he went to sign up for a gun safety training course because he knew just how dangerous guns are. And you'll also hear from my client, Skylar Coleman. She'll tell you that before Justice Carbo took a safety lesson, she gave him a liability waiver to read and sign, telling him just how dangerous the lesson could be. Second, Justice Carbo voluntarily proceeded anyway. Members of the jury, you just heard, the plaintiff agrees. Justice Carbo went to the Shooting Star. He had a safety lesson. Fortunately, the danger that he was made aware of so many times before was fully realized when he was shot in the leg. Members of the jury, we all know guns are dangerous. We all have seen the damages that they can cause. Justice Carbo was the same way. He knew the dangers, which is why, at the end of today's trial, my co-counsel, Ms. Howell, will come before you and ask for the only just verdict of not liable. Thank you.
Thank you, counsel. All right, I'm going to give the judges or the jurors a moment to enter their scores and comments. Jurors, please let me know if you are ready. Okay. Up or not. Sir Camerlingo, are you ready? Okay, thank you. I don't mean to rush you or anything like that. Make sure you have enough time. Plaintiff Carbo may present your case. As per the special instructions, you're required to call Justice Carbo as your first witness. Are you ready to proceed?
Yes.
Okay.
The plaintiff calls Mr. Justice Carver to stand.
Okay, Mr. Carbo, please step to the stand and remain seated. And when you get there, please raise your right hand to be sworn. You solemnly swear or affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth.
I do.
Okay, you may lower your hand and be seated. You may inquire.
Yes, Your Honor. Please tell us your full name and spell your last name.
The name's Carlo, Justice Carlo, and you spell it C-A-R-B-O.
Could you tell the jury a little bit about yourself, Mr. Carbo, where you're from?
I'm from West Pascal, right here in Imperial. I grew up on my daddy's tobacco farm over off of Fayette Road. The Fayette spelled like a French Lafayette, but pronounced the Fayette.
Do you live in Imperial today?
Yes, sir. I've been living here my whole life.
And are you the plaintiff in today's case?
I am.
Sir, I'd like to talk a little bit about what brought us to court today. Could you briefly explain why we're here?
Well, I went to a shooting range to learn how to use a gun, and instead of being taught how to use one, they shot me in my dadgum leg.
What shooting range are you referring to?
The shooting star.
And when did that incident occur?
It happened on May 28th, 2022.
Sir, I want to back up a second and ask you, what caused you to go buy a gun?
Well, Imperial ain't as safe as it used to be, man, so I decided I needed to get me a weapon for self-defense. Now, I had no knowledge of guns, so I needed to find a place that could sell me a weapon and teach me how to use it.
Why did you choose the defendant's shop?
Well, I was watching Wheel of Fortune one night, and this commercial for Shooting Star came on. It fit the bill perfect, you know. They said they had experts who could teach me how to use guns, and that I could buy one.
Sir, would you recognize a transcript of that commercial if you were to be shown it today?
And so,
Your Honor, I'm showing opposing counsel, Exhibit 13. What's your audience?
You may.
Sir, could you identify Exhibit 13 that I just handed you?
it's a, looks like a transcript of the commercial I watched.
And does it accurately reflect the wording of the commercial as you remember when you watched it?
Sure does.
Your Honor, the plaintiff offers both Exhibit 13, the transcript of the commercial, as well as Exhibit 12, the commercial itself into evidence, as stipulation 4 states that all transcripts accurately transcribe what it is that they were transcribing, and therefore both parties have stipulated the authenticity of Exhibit 12.
No objection.
Your Honor, we do object on grounds of more prejudicial and probative as to the actual showing of the commercial.
Well, the standard is actually not just more prejudicial and probative, because all or most evidence is prejudicial. Otherwise, the proponent of the evidence wouldn't offer it. The issue under Rule 403 is whether it's more unfairly prejudicial or probative. So I'm going to deny your objection to those points.
Yes, sir.
The exhibit will be admitted over objection.
Yes, Your Honor. And could we play the commercial for the jury to witness?
How? Shooting Star Gun Store. Are you looking for the largest selection of firearms in all of the Imperial? Then come on down to Shooting Star, where you will always be a star. We've been family owned and operated for over 40 years, and nothing is more important to us than keeping you and your family safe. Not only do we stock over 400 rifles, handguns, and shotguns, but we need to teach you how to use them. That's right. At Shooting Star, you can trade with one of our expert instructors who will teach you how to exercise your Second Amendment rights safely and responsibly. If you have learned an action from down the street or basketball or Michael Jordan, you'll be shooting like a star in no time. So come on down to shooting star gun. So he will help you protect those most important to you. Isn't that right, Jojo? Of course it is, Mom. Can I be a shooting star? We could get a little longer, son. Sure, shooting. We'll see you soon.
Shooting star, it don't matter where you are, we'll be there.
Shooting stars shall not give a light for any action customer takes to firearm, including not into negligent and reckless conduct. Customers assume all risks and responsibilities to firearm ownership and usage, exercise content, training.
Thank you, Mr. Mom. Mr. Carbo, what stood out to you about that commercial when you had watched it for the first time?
It was the part about the, learn how to shoot, you know? They told me that to learn to shoot would be like learning basketball from Jordan or, acting from Meryl Streep. I mean, who wouldn't be sold by that?
Sir, I want to move on to the day of the accident. Could you explain what happened when you arrived at Shooting Star?
Well, they sold me a weapon and then they sent me to the back to, start a training course on the shooting range.
Did you have an instructor for this training course?
Yes, sir. It was an employee, a woman named Drew Cantrell.
Could you explain how your training course went with Ms. Cantrell?
Well, it started out normal, just learning the basics of gun safety. But when it came time to demonstrate the weapon, Miss Cantrell fired the first shot downrange, and then she lost control of the gun and fired a second shot that caught my leg.
I'm so sorry, Mr. Carbo. Where were you standing when this happened?
I was behind Miss Cantrell, where she instructed me to stand.
Why were you standing there?
Just like I said, she instructed me to stand.
At any point, did you move from where you were told to stand?
No, sir. Not until I was shot and I fell.
So were you present in court today for opening statement?
Yes, sir.
And did you hear her say that you assumed the risk of being in the gun range?
Yes, sir.
What do you have to say about that?
I knew the guns were dangerous, but what I didn't assume was I would be shot by the expert teaching me how to use guns.
Thank you, Mr. Carbo. No further questions, John.
Thank you, counsel. Cross-examination?
Yes, no. Good evening, Mr. Carbo.
Hey,
You had 2 in-person meetings with Ms. Coleman before you were able to obtain your gun, is that right?
I have one.
You had 2 meetings in total, right?
That's correct.
And you obtained your gun at the end of the second meeting, is that
I
right?
did.
Now, as to this first meeting, you had an hour-long session with Ms. Coleman, is that right?
That's correct.
And on direct examination, you said you weren't taught to use a gun. Did I get that correctly?
I was taught to use a gun at the training course briefly.
You were also taught to use a gun by Ms. Coleman, right?
Well, she told me a few things, but I didn't have a gun yet, so I didn't really learn.
Right. They described safe gun handling, right?
That's correct.
Safe storage, correct?
That's true.
And made recommendations about firearms for your specific needs, right?
That's right.
You found them to be very helpful in person, didn't you?
Miss Coleman was helpful. Yes,
For this interview, you also emailed Ms. Coleman, is that right?
I did.
That was about 2 weeks before the interview.
Just about.
So just to clarify, the process of obtaining a gun from Shooting Star took 4 weeks in total, right?
Yes, ma'am.
And before you were even able to step into this training course, you had to sign a liability. Is that right?
That's right.
I'm gonna show you this paper. If I could direct your attention to Exhibit 7, I just used a packet on that stand.
Okay, on there.
You read the entirety of this waiver, is that right?
To tell you the truth, I just looked through it so I could shoot.
You chose not to read this waiver, is that correct?
And only lawyers read that.
That wasn't my question. You chose not to read this waiver,
Yes, sir.
but you signed it anyways?
Yes, ma'am. I wanted to shoot.
Permission to admit this exhibit as the defense's Exhibit 7.
Any objection?
Yes, Your Honor, to substantially more prejudice or probative, may I be heard outside the presence of the jury?
Okay, approach counsel.
Your Honor, would you like me to approach as well?
Yes. You're going to be responding. to the question. Okay. Just make sure that the jury can hear you.
Yes, Your Honor. Makes sense. According to Imperion Supreme Court case law in Guard Sky Adventures versus Guard Sky Adventures, if I could reference the case law real quick, Your Honor.
Sure.
It's the McAndrew versus Guard Sky Adventures Incorporated in 2002. It says that any liability waiver form that is signed does not bar negligence in this case, and therefore them using it to say that he assumed all the risks of anything that could happen in the gun range misleads the jury when this case law states that it does not bar negligence in hiring Mr. Cantrell, which we are pursuing.
Your Honor, may be heard.
Yes.
In order for Rule 403 to apply, the prejudice has to substantially outweigh the probative value. And as you heard in our opening statements and consistent throughout today's trial, our contention is that this witness assumed the risk by going into that, by signing the liability waiver, and that they knew the risks and they understood them before entering.
Are you claiming that, are you using this waiver to purportedly waive negligence as a valid waiver of negligence, which is against public policy?
No, Your Honor, it is our contention in today's case that Ms. Cantrell was not negligent. But we're showing this to, we're using this to show that regardless, this witness knew the risks of loss, property and damage, personal injury, and death, and that they did assume those risks. And it is also our contention that this was not caused by Ms. Cantrell, but a faulty gun, and either way, they still assume the risk.
So you're not using it for the purpose of an actual waiver of liability, then liability in your client's part, is that right?
Not fully, Your Honor, but just their knowledge of the risks.
May I respond to that, Your Honor? If you look at the first point in the liability waiver, as well as all of the consecutive ones, it talks about how all negligence will be waived the instant that they sign the waiver, and also says that the negligence of employees specifically gets waived because they assume all risks of personal injury. And by admitting this into evidence, it is substantially misleading the jury more than it would be probative.
I'm going to allow the exhibit in with a limiting instruction, okay? But the jury is instructed that exhibit number 7 is admitted solely for the purpose of the witness's knowledge of the risks of shooting, and not as a valid waiver of liability. Bless you. It's a valid waiver of liability, which is against public policy. So the jury may consider exhibit 7 solely for that purpose, and then be admitted over objection for that purpose and that personal purpose. Thank you, counsel.
Yes, Your Honor.
Yes, Your Honor. Barbara, if I could direct your attention to the second paragraph of this waiver. It says, I am fully aware of the risks and hazards connected with being on the premises and participating in the gun range. Did I read that correctly?
You did.
And these risks include as listed by the form loss, right?
Can you say that again?
The risks included loss, correct, as listed on the form?
Yes, ma'am.
Property damage, right?
That's correct.
Personal injury, correct?
That's correct.
And death. Is that right?
That's right.
You conceded any, right?
Yes, ma'am. I thought that I wouldn't get shot out there.
Just to clarify, this wasn't the first time you were made aware of the risks, was it? On direct examination, you were brought up a commercial that you've seen before, right?
It looked at I saw new shoe stars replaced by a weapon.
You said you didn't fully read the liability waiver, but you listened to this commercial, didn't you?
Yes, ma'am.
I want to direct your attention to the very last line of this commercial. It says, customers assume all risks and responsibilities associated with firearm ownership and usage. Did I read that correctly?
Yes.
And you still proceeded into shooting star gunplay by any means?
Well, didn't really hear the mamble jamble at the end of the commercial.
Just to clarify, you told me earlier that you did hear that part, didn't you?
Yeah, not very, literally.
You also testified earlier that the time, or when you read the liability waiver, that wasn't the first time you were made aware of risks. Didn't you say that?
Yes, ma'am.
So when you saw this commercial, you were aware of the risks, weren't you?
Yes, ma'am.
No. I want to talk about your training course. They again went over basic gun rules, right?
They did.
How to properly hold a gun, correct?
That's correct.
And at the time to you, it seemed as though they were safely using this gun. Is that right?
Safely used it. I got shot.
I just want to clarify why you're here today. You are here to take every penny you can from Shooting Star Gun Club. Is that right?
No,
Is your testimony today that you're not here to take every penny you can from Shooting Star?
soon.
I'll ask my question again. You are here to take every penny you can from Shooting Star Gun Club. Is that right?
That's not.
Thank you. No further questions.
Any redirect?
Yes, sir.
You may inquire.
Sir, prior to going to Shooting Star Gun Range, did you know that guns were dangerous?
Yes, sir.
Did you think that when you went to Shooting Star Gun Range, that you would have gotten shot in the leg?
I'm sure. If I thought that, I wouldn't have gone.
I'd like to direct your attention back to Exhibit 13, down to the bottom at the disclaimer. Could you read the first sentence of that disclaimer, please?
Shooting Star shall not be held liable for any action the customer takes with their firearm, including but not limited to negligent and reckless conduct.
Sir, you just read the sentence for the jury. Does it say action that you take with your firearm, or does it say action that a safety instructor takes?
Action that you take.
Does it say customer, or does it say safety instructor?
Objection, Your Honor, leading.
Well, I'm going to sustain it. Some leading is allowed on redirect, but not in that instance. You can lead to the to the point in cross-examination that you want to direct the witness's attention to, but not in that. So I'm going to sustain the objection.
Yes, Your Honor. Sir, was it in your impression in seeing this that you are liable for your gun and that anything that happens to you is your responsibility?
Objection, Your Honor, compound question.
Sustain. Please
Yes.
break it down.
So according to the first line of this sentence, who does it say is held responsible for their gun?
It says I.
And sir, were you handling the gun on May 28th, 2022?
No, sir. It was Drew Cantrell.
Thank you, Mr. Carbo. No further questions, Your Honor.
Any recross based on that?
No, Your Honor, no recross.
Okay. Mr. Carver, you have the option to leave the courtroom if you want. This time you may step down for office. At this time, I will give the judges a moment to enter their scores and comments. Just give me a thumbs up when each of the jurors is ready. Okay, Plaintiff Carvo, you may call your next witness.
Yes, Your Honor. The plaintiff calls Dr. Morgan Judd to the stand.
Okay, Dr. Judd. You solemnly swear or affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth. Okay, you can lower your right hand and be seated. Thank you. All right, counsel, you may inquire.
Yes, Your Honor. Good afternoon, Dr. Judd.
Good afternoon.
Will you please state your full name and spell your last name for the record?
Morgan Judd, that's Judd.
What do you do for a living, Dr. Judd?
I'm a researcher and a professor at the School of Public Health at Imperial State University.
Do you specialize in any particular public health field?
Yes, sir. My academic research focuses on gun violence prevention, So my work focuses at the intersection between both firearm safety, training, and prevention.
Well, Dr. Judd, I'd like to talk about why you're here in court with us today. How are you involved with the shooting that occurred at the defendant's gun range?
I was retained by Mr. Carver to assess the instructor who shot him, a woman named Drew Cantrell, and whether or not Drew Cantrell is fit to be a firearm safety instructor.
But before we dive into your assessment, please tell the jury here a little bit about your education.
I received my master's at Auburn University, as well as a PhD in public policy from Tulane University.
And what experience do you have with firearms?
To pursuing academia, I worked for nearly a decade in the Bureau of Alcohol, Tobacco, Firearms, and Explosives. My work there focused primarily on tracking down illegal firearm sales, so I received extensive training with the usage of various firearms.
And do you currently hold any gun safety certifications?
Yes, sir. I currently have a firearm safety certificate from the Imperial Justice Department.
Your Honor, consistent with Section 12 of the Court's pretrial order and Rule 702, the plaintiff tenders Dr. Judd here as an expert in firearm safety.
Any objection?
No objections, Your Honor.
Okay. This is recognized as an expert in firearm safety.
Yes, Your Honor. Dr. Judd, I'd like to return back to your assessment regarding the defendant's firearm safety instructor. Did you have the sufficient facts and data to reach conclusions about that employee's fitness to teach firearm safety courses?
Yes, sir, I did. I reviewed the written statements and depositions, including Skylar Coleman, the owner of Shooting Star, the instructor who shot Mr. Carbo, as well as the two eyewitness testimonies. I also reviewed all physical evidences related to the case.
And did you reach your conclusions to a reasonable degree of scientific certainty?
Yes, sir, I did.
What did you conclude about Drew Cantrell's fitness to teach firearm safety courses?
I concluded two things. First, that Drew Cantrell was unfit to be a firearm safety instructor due to a history of safety violations. And second, Shooting Star should not have retained Drew Cantrell, let alone promote him to the position of firearm safety instructor because he was aware of safety violations.
Please explain exactly why you made these conclusions again.
Yes, sir. Drew Cantrell had multiple red flags, multiple examples of him breaking the most basic of firearm safety rules.
Why would breaking the most basic safety rules disqualify someone from teaching a firearm safety course?
You've got to practice what you preach, but more importantly, it's about good judgment. Drew Cantrell demonstrated a lack of good judgment and respect for the dangers posed by firearms.
I heard you call those safety violations red flags. Were these red flags signs that the defendant saw?
Yes, sir. The defendant was aware of these violations. They are documented in Shooting Star records.
And would you recognize those records if you saw them in court today?
Yes, sir.
Your Honor, approaching opposing counsel with what's been marked as Exhibit 20 for identification. Permission to approach the witness.
You may.
And would Your Honor like a copy?
I think I have one of the exhibit book already.
Dr. Judd, could you please identify Exhibit 20 that I just handed you?
This is a letter from Silent telling Drew Cantrell about the safety violations.
Your Honor, we offer Exhibit 20 for evidence.
Any objection?
No objections, Your Honor.
Exhibit 20 for identification will be admitted into evidence as plaintiff's exhibit number 20.
Yes, Your Honor. Dr. Judd, how many safety violations are discussed in this letter?
Two. One in May of 2021 and another incident in November of 2021.
Just to be clear, was Justice Carbo shot before or after these violations?
So in May of 2022.
What were these violations?
The most striking incident occurred in May of 2021. Following an argument that a Shooting Star shot, Drew Cantrell aimed a firearm at another employee inside of Shooting Star shot.
Well, I think we know the answer, Dr. Judd, but what is your professional opinion of that?
Aiming a firearm at another human being from a safety standpoint is unimaginable. It violates one of the most basic safety rules, which is to never aim a firearm at anything unless you intend to shoot it.
Did the defendant terminate Ms. Cantrell's employment after this violation?
No, sir. that they promoted her.
I'm sorry, Dr. Judd. What do you mean by promoted?
You heard me correctly. When Drew Cantrell aimed a firearm at another employee, she was only a sales clerk. But less than 3 months later, shooting star promoted her to the position of firearm safety instructor. And part of her job description involved entrusting her with a loaded firearm.
Do you agree with that decision?
Absolutely not. Drew Cantrell demonstrated a lack of good judgment for the rules put in place. For a firearm safety instructor, they should show others how to safely use firearms, and in doing so, respect the rules that are put in place.
Well, then, do you have any idea why the defendant would choose to promote an employee with Ms. Cantrell's violation history?
According to the defendant's owner, it was a financial decision.
What do you mean by financial decision?
I reviewed the deposition of Ms. Adams, the owner of Shooting Star, and she said that, quote, it wasn't too bad for the checkbook.
Dr. Judd, I'm confused. How does money factor into gun safety decisions?
It shouldn't.
Well, after the defendant promoted Ms. Cantrell, did these violations stop?
No, sir. In November of 2021, Drew Cantrell brought a loaded firearm from the range back into the shop. Another very basic safety rule that was yet again broken.
Was the defendant made aware of this second violation?
Yes, sir. It's also mentioned in the display.
Did Shooting Star terminate Ms. Cantrell after the second violation?
No, sir. It did not.
Did Shooting Star at least remove Ms. Cantrell from her position as firearm safety instructor?
No, sir. It didn't.
Well, Dr. Judd, based on your expertise in firearm safety, do you agree with any of the defendant's decisions regarding Ms. Cantrell's employment as a firearm safety instructor?
Absolutely not. Drew Cantrell was unfit to be a firearm safety instructor because of her history of safety violations, and she was thought to not have retained to do herself, let alone promote her to the position of firearm safety instructor because he was aware of all of these red flags.
Thank you, Dr. Judd. No further questions, Your Honor.
Ross?
Yes, Your Honor.
May I proceed?
You may inquire.
Good evening, Dr. Judd.
Absolutely.
I'd like to start by talking about your personal history with firearms. Now, you've personally been affected by gun violence, right?
Yes.
And in response to this, you started to advocate for anti-gun laws, right?
Yes, ma'am. Firearms are quite dangerous when not handled correctly.
And I'd like to talk about your analysis in today's case. Let's start with Drew Cantrell. You believe that 2 isolated incidents in their past make them unsafer on firearms?
Yes, ma'am. They should have deemed Drew Cantrell unworthy of becoming a firearm safety instructor because they're in violations of the most basic safety rules.
However, in these 2 incidents, no one was harmed, right?
No, thank goodness no one. It could have been a lot worse.
Right, and in these 2 incidents, neither were repeated.
No, ma'am. But again, aiming a firearm at someone, that's a safety violation.
Miss Cantrell learned from that, right?
Cannot testify to what she learned, but she should have.
Because these incidents weren't repeated, right?
They were not repeated.
Now, I'd like to talk about why you think Drew Cantrell shouldn't be a safety instructor.
Yes,
You believe that the only reason Miss Coleman promoted Miss Cantrell was because of money?
yes, ma'am. One of the main factors was a financial decision.
But it wasn't the only factor, right?
No, ma'am, that was not.
In fact, one of the factors was that Miss Cantrell had a firearm safety certificate.
Yes, ma'am.
And this is the same certificate you have?
Yes, ma'am. I also possess a firearm safety certificate. But I do believe that just because someone is certified does not mean they're not qualified to do something.
Right. Miss Cantrell spent months working on her certification.
As did I.
And she also observed other firearm safety experts.
Yes, ma'am. I believe that a responsible business owner will not just entrust someone to teach the lesson without any experience at all.
Right. And Miss Coleman had Miss Cantrell gain that experience.
Through watching others. But again, teaching is very different from watching.
Ms. Cantrell observed other teachers in their lessons, right?
Yes, ma'am, but similarly, students, just because they listen to the teacher's lecture on and on, does not mean that they can recreate the teacher's talk perfectly.
Right, they were asked to examine so that they would be able to do it themselves.
Yes, ma'am, so that, yeah.
Thank you, doctor. Thank you, Your Honor. I have no further questions at this time.
Thank you. Any redirect?
No redirect, Your Honor.
Dr. Judd, you may step down. Right, and once again, I'll give the judges a moment to enter their scores and comments. Once again, just give me a thumbs up when you're ready. All right, Plaintiff Carbo, you may call your third and final witness.
The plaintiff calls Mr. Ross Hernandez.
Please remain standing, raise your right hand. You solemnly swear or affirm that the testimony about to give in this proceeding will be the truth, the whole truth, and nothing but the truth. You may be seated and know your right. You may inquire.
Good afternoon.
Hi, how are you?
I'm doing well, Mr. Hernandez. Please tell us your full name and spell your last name for the record.
Sure, my name is Ross Hernandez. Sernandez.
How old are you?
I'm 40 years old.
Where are you from?
Well, I was born and raised here in West Nashville, but my mother and father, they were both big trial lawyers back in Boston, and they worked at some firm. Anyway, they had a big court case here in 1980. I think maybe in this very court. Anyway, they loved the place so much, they decided to sell it.
Narrative.
All right, sustained.
Motion to strike, everything after the second half, yes.
Well, I'm not going to strike it since your objection just came up at that time, but I'm going to ask a plaintiff's counsel to have the witness break it down.
I'll move on. What do you do for a living?
Sure, I own my own fresh seafood market. It's called the Sapphire Shores Fresh Seafood and Market. We're bringing the taste of Back Bay right here to the people on the field.
Where is your business located in relation to the Shooting Star Gun Club?
Oh, we're neighbors, basically. I mean, we're just across the pond.
How long has your business been at that location?
Since 2012, so 11 years now.
Are you a gun owner, Mr. Hernandez?
No, I haven't even shot.
Since you're not a gun owner, do you ever visit the Shooting Star Gun Club?
Oh, yeah, sure. I go there 3, maybe 4 times a week. See, they have this little cafe there. They call it Shooter McTaverns off of that, Adam Sandler movie. Anyway, I go there sometimes for lunch, eat with a couple of my buddies, get a pizza, coffee, maybe even ice cream with a couple chocolate chips on.
Do you know the owner of Shooting Star Gun Club, Miss Skylar Coleman?
I do know Scout. She's good people.
You ever talk shop or discuss business with Miss Coleman?
Yes, we're both business people. We talk shop often. We have the same language.
Has Miss Coleman ever told you what her ultimate goal with Shooting Star Gun Club is?
Objection, Your Honor. Hearsay.
Response?
Your Honor, under Rule 801 2D2D2D, this is a statement by party opponent.
Any reply?
Your Honor, with that, the defenseman's objection under 4-3, more prejudicial and probative.
Okay, I'm going to overrule the objection. Yeah, it's a statement by a party opponent. It will be allowed.
I'll repeat my question. Has Miss Coleman ever told you what her ultimate goal with Shooting Star Gun Club is?
Sure. So about a year ago, I started seeing ads all over town for Shooting Star. And when I asked Miss Coleman about it, she told me her goal was to put a gun in the hands of every citizen of Imperial.
Mr. Hernandez, I'd like to ask you about your knowledge of certain events that may have occurred prior to May 28, 2022, when the incident we're here about today occurred. So with that time frame in mind, when you would visit the Shooting Star Gun Club, what would you observe occur at Shooting Star's gun range?
Sure, I would sometimes wander over to the gun range after I was finished eating, to see how the guys are doing, look at them doing their mass work.
Are you familiar with Shooting Star's employee named Drew Cantrell?
Yes, I do know Mr. Trump.
Have you ever observed Skylar Coleman reprimanding Drew Cantrell for work-related reasons?
I have twice.
When was the first occasion?
Well, the first time was on May of 2020.
What happened?
Well, I was just about to go into Shooter Taverns to have lunch with one of my buddies, and I hear some commotion going on behind me, so I turned around to see what it was.
Just to be clear, Mr. Hernandez, you were in the shop at the time this incident occurred.
Yes, so on one side of the shop was Shooter McTaverns, and on the other side of the shop was the gun.
Once you turned around, what did you see?
Well, when I turned around, I saw Drew in a little bit of an argument with one of the other employees. They had some sort of beef. Anyway, suddenly, Drew, who has her hand down by her side with the gun, raises her hand, the one with the gun, and points it directly at the other employee.
After Miss Cantrell raised her arm and aimed the gun at the other employee, what happened?
Well, then the room went completely silent. I mean, you could hear pins.
Once everyone went silent, then what happened?
Well, then Skylar Coleman came in, and she was not happy. I mean, I've never heard her shout so loud.
Did you speak with Miss Coleman about this incident after it occurred?
Yes, I did. So Skylar brought Drew back into her office, and then she came out with a pen and a piece of paper and asked me what all had happened preceding the incident.
And did Miss Coleman ever indicate to you whether she herself had actually seen the incident occur?
I can't say for certain whether she saw the incident or not. All I can say is that all she asked me about was what happened before the raising of the hand.
Earlier, you mentioned that you had seen Miss Skylar Coleman chastising Drew Cantrell for work-related reasons twice. When was the second instance?
Well, the second incident was in November of 2021.
What happened in November of 2021?
Well, I didn't actually see anything happen, but I heard it. I heard Skylar chastising Drew about not unloading a gun before taking it into the shop. It was one of their rules.
Thank you, Mr. Hernandez. Thank you, Your Honor. I have no further questions.
Okay, cross-examination,
Yes, Your Honor.
you may inquire.
Good evening, Mr. Hernandez.
How are
I'm great. You've seen Drew Cantrell, the shooting star, right?
I have, yes.
You try your best to avoid them, don't you?
Yes, our personalities don't mesh.
You think that their personality is insufferable, right?
Yes, at times they can.
Mr. Hernandez, you've never liked Drew Cantrell, have you?
No, we've never really got on it.
Mr. Hernandez, on direct, you testified about 2 incidents involving Drew Cantrell at the shooting star. First, you claimed that in May of 2021, you saw Drew Cantrell point a firearm at another individual, right?
I did see that, yes.
You also claimed that in November of 2021, you believe that Drew Cantrell brought a loaded firearm into the shooting star, right?
That's what I heard Skylar talking to Drew in November of 2021. Yes.
To your knowledge, Skylar Coleman reprimanded Drew Cantrell for both these incidents, right?
I believe so. Once verbally, the second time written.
And these are the only 2 incidents you've seen with Drew Cantrell at the shooting star.
The only 2 that I know of.
And neither of these situations happened in the gun range, right?
I'm sorry, can you repeat the question?
Neither of these 2 incidences you heard of happened in the gun range, right?
No, they did not happen in the gun range.
So you've never seen Drew Cantrell act unsafe in the gun range, right?
No, never in the gun.
Thank you, Mr. Hernandez. Thank you, Your Honor. I have no further questions. at this
Thank you, counsel. Any redirect based on that?
No redirect, Your Honor.
Okay, as per Empyrean regulations, so you may step down. As per Empyrean regulations, I understand the plaintiff rests at this time. We will take no more than a 5-minute break unless either side has an objection. Timekeepers, please start the clock for 5 minutes. Few minutes left. Okay. Seats once again. We're missing one or two. Okay, well, we're gonna extend that break and unfortunately for a few of our jurors. Actually, you know what? We're gonna start now. They can catch up. The Shooting Star Gun Club may present your case as per the special instructions. You're required to call Drew Cantrell as your first witness. Are you ready to proceed?
Yes, Your Honor, we are.
Okay, you may call your first witness.
The defense called Drew Cantrell.
Tell please remain standing and raise your right hand. You solemnly swear or affirm the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth.
I do.
You may be seated and lower your right hand. You may inquire.
Good evening, Ms. Cantrell.
Evening. Evening.
What do you do for a living?
I'm currently the firearm safety instructor at Shooting Star Gun.
How would you describe your relationship with guns to be?
Oh my God, I mean, I've been working with guns my entire life. I mean, back on the farm, my dad used to take me shooting all the time. I mean, I love it.
You said you work at Shooting Star Gun Club. How long have you worked there for?
I'd say a little over 3 years.
What position did you start out with there?
Well, that was really a case of, how did those city boys say, started from the bottom, now we're here? I mean, I started from the bottom, honestly. I started with sales and inventory, and I worked my way up. I went through the process of certification, and now here I am as firearm safety instructor.
Now, what was the interview like to work in sales?
Well, let me tell you, that thing was thorough. I mean, I'd say it took a little over an hour. I was asked about, you know, my experience with guns. I had to fill out a bunch of government paperwork and turn in my driver's license. I believe I also filled out what looked like a background check.
And now you work as firearm safety instructor. What steps did you have to take to obtain that position?
So initially, before I even got the position, I went through the process of firearm safety certification, just to make sure I knew how to use guns safely. And once I actually got the position, I went through firearm safety instructor certificate. The process of that, just to make sure I knew how to instruct others how to safely use guns.
Who oversees you at Shooting Star Gun Club?
That would be my boss lady, Miss Coleman.
How would you describe your relationship with Miss Coleman?
Well, you know, I actually said it's pretty positive. You know, I really like her. But with all relationships, you know, we did have a few hiccups.
What were these hiccups?
Well, you know, there were 2 instances in which I was actually written up, you know, but trust me, Coleman was pitching a hissy fit. I mean, she was hollering at me and she would just yell at me, but you know, I took her yellings as I took them because, you know, I understand that takes time.
I want to talk a little bit more about these incidents. Can I direct your attention to Exhibit 20, which has been admitted? What is this?
I believe this is the memorandum of the 2 instances I was written up for by.
I want to take these instances one by one. Does the memorandum address both of them equally?
Looks like it.
I'm going to talk about that first one. Can you describe what happened in that first incident?
Yes, well, in May of 2021, you know, I was inspecting a gun in the gun shop like I normally do. You know, I was pointing it at the ground like I was instructed. But that's when Miss Coleman started pitching a hissy fit. I mean, she was yelling at me, telling me not to point a gun at any other person. But trust me, I know I was a 21. I mean, I would never do that. I knew the rules. And so honestly, it was just a big misunderstanding. But again, I took those talking to because I understood that safety came first, no matter what.
Just to clarify, did you point a gun at another individual?
Absolutely not.
That first incident, can you describe what happened there?
The first one or the second?
The second one, excuse me.
Yes, ma'am. This one was in November of 2021. And this one, I was in the shooting range. I had a gun And, it was honestly, it was a little mistake, I took the gun out of the gun range and I took it into the shop. I really shouldn't have. I was really focused on my horse, Gilbert stick. But, I got another stern talking to from my boss lady. She really ingrained it into my head that I shouldn't have done that. And I really learned my lesson.
Did you understand your mistake?
Yes, ma'am. And again, I never followed through with it, doing it again.
So just to clarify, did you ever repeat either of these mistakes?
No, ma'am.
In reference to that first incident, how did you feel about being held accountable for something you didn't do?
Oh, man, I was madder than a wet hen. But again, I understood that safety came first no matter what. Even if I didn't do it, I just took those talking to because, again, safety is so important.
I want to talk about May 28th. Did you teach a training instruction that day?
I did. That day, I was told I would be instructed, with this Justice Carbo and Nick Albright had to, Carbo block.
How did you perceive their familiarity with guns to be?
Well, let me tell you, they seemed like pretty boys to me. I mean, it didn't really seem like they knew anything about guns. So I really went over the building blocks of safety, I even gave them warnings about guns. Those are dangerous things, and it's usually pretty common for beginners to flinch at the recoil of a gun. And I also gave them safety equipment.
So Ms. Cantrell, just to clarify, did you approach this lesson differently knowing that they were beginners?
Yes, ma'am.
Did you take extra precautions?
Oh, absolutely. I made it clear what all the safety precautions were.
What were some of these safety precautions?
Well, I went over the main ones, don't point a gun at nothing unless you intend to shoot it. Keep your finger off the trigger unless you're ready to shoot. And, don't point the gun at anything you don't.
Did you provide them with any safety equipment?
Yes, ma'am, I believe that was earmuffs and goggles.
How did the lesson proceed?
Well, I did the first step by placing Carbo in a distinct spot and Nick Albright to the right, just to make sure that they were clear on where to stand when I was doing a demonstration of how to shoot a gun safe.
And did you place them a safe distance away from you?
Yes, ma'am, I did.
Did you ever actually end up shooting a gun?
I did, and I want to be clear, I only shot the gun once, and it was purely for demonstration purposes. I was standing in the middle of stall 11, I had the gun, I was getting ready to shoot it, and that's when I fired the first shot, and it was really violent. And I tried everything that I learned to maintain the gun. I tried to absorb the force of the recoil with my right arm, and I tried to maintain my hold of the gun. And that's when I got a real bad hit to my right arm. Honestly, that's when all hell broke.
Said you got a bad hit to your right arm. Who hit your arm?
I believe it's Justice Carbo, man.
Has this ever happened before?
I mean, this has never happened before. I mean, even the recoil, I've never felt anything that strong. I've never had anyone hit me during a lesson. I mean, this is also different from anything I've ever experienced.
Did you properly handle the gun during that lesson?
Yes, ma'am, absolutely. I mean, I tried everything I could to ensure the safety of everyone. Like I said, I tried everything I've learned. I tried absorbing the force of that recoil. I tried using my arms to absorb that force, but that hit to my arm, it was just too strong.
Thank you, Ms. Cantrell. No further questions, Your Honor.
Ross.
Yes, Your Honor.
Reply.
Ms. Cantrell, you would agree with me that, or firstly, I want to talk about your fitness as a firearm safety instructor. Prior to being hired by the defendant, you had never worked as a firearm safety instructor anywhere else. That's right?
That's correct.
So you had no prior employment experience regarding firearm safety instruction, yes?
No, sir. That's why I had to go through the process of certification.
In fact, ma'am, you had never worked at a job that involved firearms before. Is that right?
Prior to becoming a firearm safety instructor?
Prior to being hired by Shooting Star, you had never worked at a job that involved firearms. That's correct?
That's correct.
You would agree with me that a firearm safety instructor should be careful, not reckless. Do you agree with that?
Oh, absolutely, sir.
And prior to being hired as firearm safety instructor, you were required to fill out a background check form, is that right?
I believe so, yes.
And this background check form, as you said, was through the Imperial State Department, that's correct?
I believe so.
Your Honor, I'm showing opposing counsel exhibit 21. Ma'am, exhibit 21 that I just handed you, that is your criminal record, correct?
Yes.
It's an accurate copy of your criminal record? Your Honor, the plaintiff offers exhibit 20 into evidence.
Any objection?
Yes, Your Honor, under Rule 403, as this is substantially more prejudicial than it is probative.
Response?
Your Honor, the prejudicial value of this exhibit does not substantially outweigh the probative value for two reasons. Firstly, this document goes to the knowledge that Ms. Coleman would have had in hiring Ms. Cantrell, and whether she knew or didn't know about it could substantially affect the weight of that this goes to the jury in a negligent hiring and retention case. And secondly, Your Honor, this is highly probative because it goes to show that these past actions, if Ms. Coleman had known about them, she may not have hired Ms. Cantrell.
Any reply?
Yes, Your Honor, just the fact that Ms. Coleman didn't, or excuse me, that they knew about this criminal record in general is enough to establish the probative value, but the prejudice is introduced by the specific acts themselves, as those are not relevant to any cause rather than to induce prejudice from the jury.
Well, I think it's definitely prejudicial, but most evidence is prejudicial to one side or the other. But I don't think it's unfairly prejudicial. I think it goes to the issue of notice of your client, of her criminal background. So I'm going to overrule your objection and allow it into evidence.
Yes, Your Honor.
Yes, Your Honor.
Exhibit 21 will be admitted. Exhibit 21, plaintiff's exhibit 21 for identification will be admitted to evidence as plaintiff's exhibit 21.
Yes, Your Honor. Now, in 2014, you pled guilty to reckless driving, is that right?
Yes.
You ran a stoplight, correct?
Yes.
And in 2016, you pled guilty to a hit and run, that's correct?
Yes, sir.
You sideswiped a parked truck and then kept driving, is that right?
I mean, I really didn't realize that I had, but yes, sir, that's what it said.
And in 2018, you pled guilty to drinking while under the influence of alcohol, that's correct?
Yes, sir.
You got behind the wheel after a night out at the bar, didn't you?
Yes, sir. I mean, I was young. I really learned my lesson from this. I mean, my nana right about killed me.
And then you were stopped by the police after you ran a stop sign, that's correct?
Yes.
And then you proceeded to fail a field sobriety test, that's correct? Now, ma'am, all of these convictions, they could be seen by any prospective employer that runs a background check through the Imperial State Department, the entity that maintained your criminal record, that's right? Now, ma'am, I want to talk about your interview with the defendant. Prior to interviewing with the defendant, you had just been fired from your previous job for drinking on the job, that's correct?
I mean, I know I wasn't drinking. I know I wasn't drunk, but that's why I was fired. Yes.
Well, ma'am, in your interview, Ms. Coleman never asked you why you had left your previous job, did she?
I don't believe she did.
That's a yes, she didn't.
She did.
And no one at Shooting Star Gun Range at any point ever asked for a reference from your former employer, that's right?
Never.
And now when you were hired by the defendant, your unsafe behavior continued, didn't it?
I mean, there was really only one incident, but it was minor, but yes, sir.
Now, I'm sure we can agree that pointing a gun at another person is not safe behavior, can't we?
Oh, I would absolutely agree, but I did not do.
I'd like to reference exhibit 20 that you should already have. You know when you got there? No, ma'am, please read silently as I read aloud. I received a report that in violation of company policy and best practices, you aimed a firearm at another person in the gun shop following a verbal argument. I read that correctly?
Yes, you did.
Now, ma'am, you say that you didn't do it, but regardless, Mr. Coleman wrote you up for it because he believed it could have happened. That's right?
I mean, I don't know what Coleman believes, but this is what it said.
Ma'am, Mrs. Coleman received a report that you had pointed a gun at someone, that's right?
I believe so.
You believe that they received a report? Or she did receive a report?
Objection, Your Honor, lack of personal knowledge. This witness cannot testify as to whether Ms. Coleman actually received a report.
Sustained.
Yes, Your Honor. Now, ma'am, in reference to the incident on May of 2021, in the write-up that Ms. Coleman gave you, it says that she received a report that you had pointed a gun at someone else, that's right?
That's what it says here.
And after May of 2021, your unsafe behavior did not stop there, did it?
Yes, sir, I did have a minor incident that I was hollered at.
That incident was in November of 2021, wasn't it?
Correct.
You brought a loaded gun out of the shooting range and into the storefront, that's correct?
Yes, sir, and I took full responsibility for that, and I got stern talking to, but yes, sir. I was.
And Mr. Coleman was aware of that incident.
Yes, sir, that's why she wrote me up for it, and that's why I also, she gave me a stern talking to.
And just to be clear, after she wrote you up for the May 2021 incident, she promoted you to firearm safety instructor, didn't she?
3 months after, yes, she did. I did not have any incident, after May 2021, before November.
That's a yes, it was after the May 2021 incident. And then after the November of 2021 incident, she retained you, didn't she?
Yes, sir.
Thank you, Ms. Cantrell. No further questions, Your Honor.
You redirect?
Yes, Your Honor.
Inquire.
Carl, I want to direct your attention back to Exhibit 20. Any of these incidents listed on your criminal history, gun-related incidents?
Absolutely not, ma'am. And, I did learn my lesson from all of them.
Did you start out at Shooting Star Gun Club as a firearm safety instructor?
Absolutely not, ma'am. Like I said, I had to work my way up. I started out in simple sales.
Just to clarify, did you have to gain experience with guns in order to become a safety instructor?
Oh, absolutely. I mean, like I said before, I had to go through 2 processes of certification.
Thank you. No further questions.
Any recross based on that?
No recross-examination, Your Honor.
Okay, you may step down, Ms. Cantrell. All right, once again, going to give the judges a moment to enter their scores and comments. Just, jurors, give me a think about when you're ready. All right, defense, please call your next witness.
Yes, Your Honor, the defense called Skylar Coleman instead.
Ms. Coleman, up to the stand, and as you do, please remain standing and raise your right hand. Do you solemnly swear or affirm that the testimony about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may inquire.
Good evening, Ms. Coleman.
Good evening. What do you do for a living?
I work at the Shooting Star Gun Club. I'm
Actually, the owner.
Now, what is the Shooting Star Gun Club?
Well, like it says in the name, it is a gun club. So we offer a variety of firearms for sale, a shooting range, a bar, and a cafe. Foster a community.
And as owner, do you do anything specific?
Well, not exactly. Since I am the owner, anything from hiring to advertisements to rent, all of it has to go through.
And are you aware of an individual by the name of Drew Cantrell?
I am. I hired Ms. Cantrell back in June.
What was their hiring process like?
Well, as with any other hiring process, I expected them to turn in a job application, which I reviewed and called them in for an interview. And I asked a few questions. questions to see if they would fit in well with our company and our role. And I found them they did.
Now, what position did you exactly hire them at?
I was hiring for a firearm sales clerk at that time. I also found throughout my interview that Ms. Cantrell had a lot of gun knowledge, which was exactly what I was looking for at that time.
Under your employment, did they stay as a sales clerk?
No, they did not. In August of 2021, I promoted them to firearm safety.
Did you set any requirements to become a safety instructor?
Yes, ma'am, I did. So in order for Ms. Cantrell to become a firearms safety instructor, I expected her to earn their firearms safety certificate from the state of Imperial and gain some experience by watching other training.
Did they meet those requirements?
I believe they did.
Now let's talk about Drew Cantrell as an employee. How did you view them as an employee?
Ms. Cantrell was great with the employees and with the customers from what I could see, and there was really only 2 violations of company policy during her time.
Let's talk about those incidents. What happened with the first one?
Well, the first incident was May of 2021, and allegedly Ms. Cantrell had pointed a gun at another employee.
Now, Ms. Coleman, you said allegedly. Do you know if Drew Cantrell actually pointed a gun at another person?
I couldn't be sure, ma'am. That was simply what I was told.
Did you reprimand them for this incident?
Of course I did, ma'am. Gun safety is our #1 priority at Shooting Star Gun Club. So I informed them, I told them that this kind of behavior was not acceptable.
Now, after you reprimanded them, did those actions ever continue?
No, ma'am, they did not.
Now, you stated there were 2 incidents. What was that second?
The second incident was November of 2021, and again, allegedly, Ms. Cantrell had left the shooting range with a loaded gun.
Did you reprimand them for that incident?
Yes, ma'am, I did.
Did those actions ever continue?
No, ma'am, they did not.
Now, let's talk about someone. Do you know an individual by the name of Justice Carter?
I do. Mr. Carbo emailed me early May of 2021 about purchasing a firearm.
Did you ever meet with Justice Carbo in person?
Yes, ma'am. I'm not the best over email, so I told him to come down to the store so we could figure out what was best in terms of firearms.
Did you figure out what firearms was best?
Yes, so Mr. Carbo had informed me that they were a beginner with guns and that they really needed one for self-defense. So, taking those factors into account, we decided that a Glock 22 would be the best.
And did Justice Carbo end up buying a firearm?
Yes, they did.
Now, taking into account that they were inexperienced, did you do anything to prepare them for this gun?
Yes, ma'am. So at Shooting Star Gun Club, we have a complimentary safety course that we offer every single customer, new or experienced. And I went ahead and offered this course to Mr. Carbo.
Did Mr. Carbo partake in this course?
He did, ma'am.
Now, could he just go to this course, or did he have to do something before?
Well, I expected him, along with all of my other customers who want to take the safety course, I expected him to fill out a liability waiver.
Would you recognize this liability waiver if I presented it to you in court?
I'm sure I would. I hand one out to almost every customer.
At this time, I'd like to direct the court and the witness to Exhibit 7.
Is it in?
Yes, ma'am. Your Honor, permission to publish to the jury what has been admitted as Exhibit 7.
You may.
Are you there, Ms. Coleman? I am. Is this the liability form you gave to Justice Carter?
Do I have a minute to read over?
Of course, Ms. Coleman. Why did you give this liability form to Justice Carter?
Well, ma'am, at Shooting Star Gun Club, we know guns are dangerous. Which is exactly why we want all of our customers to be able to acknowledge the risk of taking this course and of entering the shooting range before they, get themselves into it.
And did Justice Carbo sign this document acknowledging those risks?
Yes, ma'am, right here.
Thank you. I have no further questions at this time.
Thank you, Kim. Cross-examination.
Yes, Your Honor.
Inquiry.
Good evening, Ms. Coleman.
Good evening.
Now, you are the sole owner of Shooting Star Gun Range, that's correct?
Gun Club, yes.
And so it's fair to say that you're a businesswoman, right?
I like to call myself that.
And it was your decision to hire Drew Cantrell as a sales associate in June of 2020, that's right?
That's
It was also your decision to promote Drew Cantrell to firearms safety instructor in August of 2021, that's right?
That's
Now, I'd like to talk about what Shooting Star knew, or rather should have known, when you made those decisions. You never performed a background check on Drew Cantrell, did you?
Yes,
So you never obtained a copy of Drew Cantrell's criminal record,
that's correct.
not when you hired him initially,
No,
and not when you promoted her to firearms safety instructor, that's right?
that's correct.
And Ms. Coleman, you are aware that a prospective employer can obtain the criminal record of a prospective employee by simply running a background check, right?
That's correct, but I had known Ms. Cantrell prior to her application and interview.
Well, you simply chose not to run that background check because of your prior knowing, right?
Yes,
Now, let's take a look at what you would have found had you checked. Your Honor, I'm approaching defendant's counsel with what's been previously entered as Exhibit 21. I believe the witness already has a copy of Exhibit 21. Yes, that's it. Now, at the top of Exhibit 21, it says Imperial State Department Certified Criminal Record. You see that?
Yeah.
And the name listed here is Drew Cantrell, right? Yes, in the top left corner.
yes,
You see that in 2014, Drew Cantrell pled guilty to reckless driving. You see that?
Objection, Your Honor, under 403, cumulative.
I'm going to overrule the objection.
Yes.
You may answer.
You see that in 2014, Ms. Cantrell pled guilty to reckless driving. That's right.
that's correct.
In 2016, Ms. Cantrell pled guilty to hit and run. That's right.
That is correct.
And in 2018, Ms. Cantrell pled guilty to driving under the influence. That's right.
That's correct.
But because you did not perform a background check on Ms. Cantrell, you did not know any of this when you hired Drew Cantrell or promoted her to firearms safety instructor. That's right.
Sir, I don't see how these are relevant to the position.
That's a yes to my question. You did not know any of this when you hired Drew Cantrell or promoted her to firearms safety instructor.
No, sir, I didn't.
You'd agree that a firearms safety instructor should be a careful person, not a reckless one, right?
I don't think.
They should be a safe person too.
I don't think so.
Reckless driving, hit and run, DUI? Are these the actions of a careful person?
Objection, Your Honor, compound question.
Sustained. Rephrase.
Is reckless driving the action of a careful person?
Sir, I do not know the context of
I'm not asking about these misdemeanors. I'm asking if reckless driving is an action of a careful person.
I'm not sure.
You're not sure if recklessly driving on public roads is the action of a careful person?
Sir, I cannot.
All right, then let's look at the other charges. hit and run, is that an action of a careful or safe person?
Objection, Your Honor, speculation.
Overruled. It's cross-examination. You must answer.
Is hitting and running from the crime scene the action of a careful or safe person?
I'm not.
You're not sure if breaking the law and endangering public safety is not the action of a careful or safe person? So is is a hit and run the action of a careful person? Yes or no?
I suppose.
Is driving under the influence the action of a careful person? Is it the action of a safe person?
No.
The truth is, Ms. Coleman, is that if you had known about this criminal record, you would have never hired Drew Cantrell in the first place. That's right.
I suppose so. I cannot, I don't, I suppose so, yes.
I'd like to talk about why. The real reason you promoted Drew Cantrell was because it was good on the checkbook. That's right. So you did not promote Drew Cantrell because it was good on the checkbook?
That was a part of the reason why, but not the entire.
Now, you say that wasn't the entire reason, but when you interviewed Drew Cantrell you had no idea whether or not she had ever worked with guns before.
Well, she did show a lot of gun knowledge.
But gun knowledge is different than gun experience. That's right.
Correct. I was hiring for a sales position, not a trainer.
Well, when you promoted her to firearm safety instructor, you had no idea whether or not she had ever taught classes.
No, which is why I expected her to earn her certificate and gain experience.
And you say she gained experience, but that experience was just watching other firearm safety instructors. Isn't that right?
That's correct.
Now, Ms. Coleman, I love to listen to Taylor Swift, but does that mean I can sing like Taylor Swift?
Objection, Your Honor.
Overruled. It's cross-examination. You can answer.
So does that mean Drew Cantrell, just because they watched other instructors, could be a firearm safety instructor?
Well, prior to this incident, there's never been an incident like that in the shooting.
I'm asking whether or not just watching firearm safety instructors makes someone a firearm safety instructor. Does it?
Well, along with the certificate, it does, I would say so.
Now, what was that certificate?
Firearm safety.
But that firearm safety certificate does not teach you how to instruct a firearm safety course, does it?
No, sir.
So now I'd like to talk about why, now, after hiring Drew Cantrell, she pointed a gun at another person. That's right.
In May of 2021, now that was what I was told.
You thought it rose to the severity that you had to file a memorandum, formal warning letter to Drew Cantrell. That's right.
Not exactly.
So it's your testimony that you did not file a warning letter to Drew Cantrell after she pointed a gun at another employee?
No, sir, that's not.
But do you remember that, Your Honor, I'm approaching the witness with Exhibit 20? It's already been entered into evidence. And Ms. Coleman, at the top of Exhibit 20, now, Ms. Coleman, what is this?
It is a memorandum I wrote with the incident on May 2021 and November 20.
This was that formal warning letter? That's correct?
That's correct. However, we do keep track of every single incident, not, doesn't depend on severity.
Well, you said in this letter, you have failed to conform with the standards expected of Shooting Star employees. That's right?
I did.
And you listed the incident where Drew Cantrell pointed a gun at another person as a reason for this warning letter. That's right?
I'm sorry, could you repeat that?
The reason here cited for formal warning letter is Drew Cantrell pointing a gun at another person. That's right.
There were two violations that referring to partly, yes.
If a customer came into your shop and pointed a gun at another person, you would kick them out, wouldn't you? But when Drew Cantrell pointed a gun at another person, you did not kick them out, did you?
I did reprimand them and they did show improvement in their behavior.
But you didn't fire them?
No, I did not.
Instead, you promoted them to firearm safety instructor. That's right.
I did after they earned their certificate and their experience.
So they could teach classes to people like Justice Carver.
Yes, to all customers.
Thank you, Ms. Coleman. No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
You may inquire.
Ms. Coleman, I'd like to direct your attention back to Exhibit 20. Are you there? Now, it's brought up on cross-examination that you didn't see this criminal history. Did I get that right?
Ma'am, are you talking about exhibit 20 or?
21.
Oh, my apologies. I haven't.
It was brought up on cross-examination that you've never seen this criminal history. Did I get that right?
Objection, Your Honor. Leading.
Well, it is leading, but she's leading her to a point in cross-examination, and that kind of leading is allowed.
Yes, Your
So, you know, overrule the objection.
Yes, Your
You may answer the question if you want.
Yes, ma'am. It was brought up on cross-examination that you've never seen this criminal history before. Did I get that right?
That's,
Now, do any of these incidents on this paper talk about guns?
I don't believe so.
Are any of the incidents related to guns? And would this criminal history affect your decision in hiring Drew Cantrell?
Not necessarily, ma'am. I don't see how any of them are related to her responsibility of, working the cash register and taking inventory. This was a position I was initially hired for.
You also stated on cross-examination that you knew Drew Cantrell before hiring. Do you believe that they're a safe person?
From what I've seen, throughout their employment, they do seem to be a safe person. I sat in on a few of their instruction courses after they were promoted, and the customers seemed to love her. Excuse me.
Do you believe that Drew Cantrell is a careful person?
I do.
Now, I'd like to direct your attention to Exhibit 1. Is this a memorandum you filed?
Yes, it is.
And why did you file a memorandum?
Well, I needed Ms. Cantrell to understand that this sort of behavior was not allowed or acceptable at the Shooting Star Festival.
After you reprimanded them, did they ever do any actions like these ever again?
No, ma'am, they did not.
Thank you. I have no further questions at this time.
Thank you, Counsel. Any recross on that?
No cross-examination.
Okay, Ms. Coleman, you may step down. Once again, I'll give the judges a moment to enter the scores and comments. Just once again, give me a thumbs up when you're ready for it. Okay. All right, you have one more witness?
Yes, Your Honor. This defendant calls Jackie Stobbs.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. May inquire.
Thank you, Your Honor. Good evening, Ms. Stobbs.
Good evening.
Are you currently employed?
I am. I'm currently a firearm and toolmark examiner at my very own firm, Staub Examiners LLC.
Why did you decide to open your firm?
Well, after everything I've seen in the military, I decided it was important everybody had access to the proper firearm safety training.
What is your experience with firearms?
I have firearm safety certifications from the Imperial government, as well as United States Bureau of Alcohol, Tobacco, Firearms, and Explosives. I was also in the Army for 7 years, where I qualified as an expert pistol shot.
And have you published any works on firearm safety?
I have. I published an article on firearm safety in 2020.
Your Honor, the defense now moves to tender Ms. Staub as an expert in firearm safety.
Any objection?
No objection, Your Honor.
This is accepted as an expert in firearms.
Ms. Staub, how did you get involved in today's case?
I was hired by defense counsel to provide my analysis on today's case.
And what materials did you review in order to conduct your analysis?
I reviewed all the affidavits and depositions in today's case, as well as multiple exhibits in the exact block 22.
What did your analysis focus on in today's case?
I looked specifically into Shooting Star Gun Club's employee, Drew Cantrell.
Why did you look specifically into Ms. Cantrell?
On May 28, 2022, during a firearms safety course led by Drew Cantrell, Justice Carbo was shot.
Ms. Staub, why do you believe that Mr. Carbo was shot?
I believe it was due to problems with the firearm.
What problems with the firearm did you identify?
I found that there was an overly sensitive trigger, as well as a harsh recoil.
Ms. Staub, why is an overly sensitive trigger significant?
An overly sensitive trigger means it takes less force to fire the gun.
And why is a harsh recoil significant?
The harsh recoil combined with the sensitive trigger makes it easier for the trigger to be depressed once again.
Did you do anything else in your analysis to look into Ms. Cantrell?
Yes, I looked into whether or not Drew Cantrell was certified to run the safety training course.
Now, was Ms. Cantrell certified?
Yes, ma'am. She had firearm safety certificates from the Imperial government, as well as a firearm instructor certificate.
And was this the only thing you believe why Ms. Cantrell should be a firearm safety instructor?
No, I also looked into Drew Cantrell's history with firearms.
What does their history look like?
In around 20 years of experience, I found only 2 firearm safety related incidents.
Do you believe that these 2 incidents make Ms. Cantrell unsafe around firearms?
No, I do not. These are only 2 experiences in around 20 years.
Ms. Staub, so what was your conclusion in today's case?
I found that the retention of Shooting Star Gun Club's employee, Drew Cantrell, was safe.
Thank you, Ms. Staub. Thank you, Your Honor. I have no further questions at this time.
Thank you, John. Cross-examination.
Yes, Your Honor. Good evening, Ms. Staub.
Good evening.
I'd like to start with what happened just before my client was shot. You're aware that in the moments prior to the shooting, the defendant's safety instructor was aiming the pistol downrange towards the target,
That's correct.
and my client was standing behind that safety instructor's right shoulder. That's fair?
That is.
And somehow that safety instructor lost control of the gun and shot my client standing behind him, her, in the leg. That's right.
I don't believe it was their fault, but that is what happened.
Now, it goes without saying, Ms. Staub, but a firearm safety instructor should not shoot their trainee in the leg. That's right.
Once again, I don't believe it was their fault, but that's correct.
A firearm safety instructor should not lose control of a loaded handgun. That's right.
That's correct.
Now, I heard your direct examination and I've read your report cover to cover. Nowhere do you blame my client at all for what happened to him, do you?
No, I believe it was due to problems with the firearm.
And you certainly didn't conclude that my client assumed the risks, even after exhibiting and analyzing all the evidence, including Exhibit 7 in this case.
That's correct.
It's your opinion that the most likely cause for the second gunshot was an overly sensitive trigger. I've got that right?
Combined with a harsh recoil, yes.
So you're not blaming my client or the defendant's safety instructor at all, are you?
No, once again, it was due to the gun.
All right. So you examined the gun in this case?
I did.
It was a Glock 22.
It was.
A Glock 22 is a gun suitable for novices. That's right.
Yes, it is.
Since it's suitable for novices, a competent firearm safety instructor should know how to safely handle a Glock 22. That's fair?
That is fair.
A competent firearm safety instructor should know how to control a Glock 22. That's right.
That's right.
Now, you told this jury that the Glock 22 you examined in this case had an overly sensitive trigger. But isn't it true that all Glock 22s are known for having this overly sensitive trigger?
Well, in general, Glock 22s are known to have a sensitive trigger. However, this specific Glock 22 had an overly sensitive trigger.
I'd actually like to talk about that, how you came to that conclusion. You examined the gun, but you never ran any tests, did you?
That's correct.
You never fired the gun, that's right?
I did not.
So you have no test results to prove your conclusion that this gun in particular had an overly sensitive trigger, different than a typical Glock 22, do you?
I don't. However, I reviewed many affidavits and depositions.
So you have no empirical data to objectively conclude that this Glock 22 was any different than a typical Glock 22, do you?
That's correct.
Right. And you'd agree, Ms. Staub, that a safety instructor should know how to use the gun they're demonstrating, right?
They should.
In fact, it's their responsibility to know how to use the gun before demonstration. That's right.
It is.
So if a safety instructor does not know how to use a particular type of gun, then they should not teach a course with that gun to a trainee, should they?
That's correct.
So if Drew Cantrell did not know how to safely handle a Glock 22, then she should not have been teaching that course to my client that day, should she have been?
She shouldn't have. However, I do believe she was handling the Glock 22 safely.
So she shouldn't have been teaching that course to Justice Carver that day, should she? That's your testimony?
Yes.
Now, you'd also agree that incompetency on the part of Shooting Star's safety instructor could explain what happened in this case. Right?
I believe it.
Right. Because flinching or because holding a Glock 22 with an overly relaxed grip, that could have caused a second inadvertent shot. That's right.
It could have. However, I believe it was due to the overly sensitive trigger in the harsh recoil.
But holding a Glock 22 with an overly relaxed grip could cause the gun to become unmanageable and dangerous, right?
It could.
So a competent firearm safety instructor should not hold a Glock 22 with an overly relaxed grip. That's right.
That is right.
So you'd also agree that flinching prior to shooting, that could also cause the second shot. That's right.
It could.
And flinching is a trait typically associated with novices. Sir?
That is typical.
Right, so a competent firearm safety instructor should not flinch prior to shooting. You agree with that?
I would agree, and I don't believe they flinched.
Right, but at least one eyewitness's statement you read in your analysis detailed Miss Cantrell to have flinched prior to shooting. That's right.
That's right, and I do also have another witness that says the opposite.
But nevertheless, at least one eyewitness's testimony you read detailed Miss Cantrell flinching prior to shooting. That's right.
There was one, however, their lack of experience in firearms led me to not believe it.
My question is a little simpler. At least one eyewitness did testify to that. That's right.
That's right.
Thank you. No further questions.
Thank you, counsel. Any redirect based on that?
Yes, Your Honor.
You may inquire.
Ms. Staub, opposing counsel just got up before you and asked you a lot of questions about whether or not Mr. Carbo assumed the risk. Was your analysis focused on whether or not Mr. Carbo assumed the risk?
No. It was on whether they were qualified to run the course and if they act safely.
And had Ms. Cantrell handled a handgun like the Glock 22 before?
Yes, on November 16th, 2022.
And was this handgun like a regular handgun?
It was. It was a Glock 22.
Did you identify any problems with it?
No, I did not.
Did any eyewitness say that Mr. Carbo flinched?
No.
Thank you, Ms. Dodd. Thank you, and I have no further questions.
Any recross based on it?
No recross examination.
Okay, we will step down. Okay, as per Imperial regulations, I understand the defense rests its case at this time. We will take no more than a 5-minute break before closing arguments unless either side has an objection. Timekeepers, can you please set the clock for 5 minutes? Thank you. And we can keep it, jurors, to 5 minutes strictly. Thank you.
We having fun?
Yeah. What a difference a week it is.
Right. Yeah.
Yeah. See this through the end.
Love that you're here.
All right.
Right, yeah. Yeah. So. Here and then. Once the closings are done, they give them around long, wait a few minutes, I'll clock on.
Okay. Sure. All right, in this jurisdiction, the plaintiff presents its closing argument first. Counsel for Justice Carbo, how much, if any, time would you like to reserve for rebuttal? I believe my understanding is you only have six minutes and 23 seconds left. Is that right?
Yes, Your Honor, I would like to reserve any of my remaining time for rebuttal.
Okay, whatever is remaining after your opening close. Or summation, I should call it. And, okay, you may proceed.
Yes, Your Honor. May it please the court, opposing counsel, and members of this jury. The signs were there. That's what Mr. Obery told you at the beginning of today's trial. And now we can see that he was correct. Miss Drew Cantrell was unfit to be a firearms safety instructor. Her criminal history littered with careless and reckless mistakes, aiming a gun at a fellow employee in the shop, a pattern of mistakes on the job, violating critical gun safety rules. The only problem is that the defendant just didn't care. You learned today in trial that Miss Cantrell was hired because it was good on the checkbook. Miss Cantrell was hired for money, not for safety. What they didn't tell you is that an employee had just left the job and she needed someone to fill their shoes. So she hired Miss Cantrell, even though she lacked the experience and training. And my client, Mr. Carbo, he paid the price. Now, you also learned today that when Mr. Carbo watched the commercial that was on television that the defendant made, he was tricked. He was tricked into believing that they were the best of the best, that they were the experts. Members of the jury, you watched this commercial in trial today. You heard them say that if you come on down to Shooting Star Gun Club, it'll be like learning acting from Meryl Streep or basketball from Michael Jordan. The only difference being is that Meryl and Michael, they're not going to shoot you in the leg in the middle of your class. Shooting Star Gun Club didn't hire the Meryl Streep or the Michael Jordan of gun safety training. They hired someone who was careless and reckless. They knew it, and they should have known it. Now, as the plaintiff, we carry the burden of proof. We must prove that it's more likely true than not that Miss Cantrell was unfit to be a firearms safety instructor, and that her hiring caused Mr. Carbo's injury. And throughout the trial, we've proven 3 facts that all mean that we've met our burden. Fact number 1, Miss Cantrell was unfit to be a firearms safety instructor. Fact number 2, Shooting Star Gun Club knew and should have known that she was unsafe to be a firearms safety instructor. In fact number 3, they still put a gun in the hands of Miss Cantrell to teach Mr. Carbo's safety course. I'll break each of these down one at a time, starting with the first fact. Miss Cantrell was unfit. You learned today that she committed 2 safety violations. In May of 2021, she pointed a gun at someone in the store. In November of 2021, she brought a loaded gun out of the shooting range and into the storefront, violating a vital safety rule that Shooting Star Gun Club has posted on the front of their gun shop. You also learned that she has a criminal history filled with careless and reckless behavior. Now, that only leaves it to, was she trained? Members of the jury, the answer is no. She only received certification, not qualification. You learned today that the only way that she received any experience whatsoever in teaching for firearms was by watching other courses. Members of the jury, you can't sit in a math class and then get up and teach the math class. It's not how it works. Fact number 2, Shooting Star knew and should have known that she was unfit. You learned today that Ms. Coleman wrote a memorandum outlining both the May 2021 and the November 2021 incidents, saying that they were a breach in employee conduct. acknowledging that they breached the rules of Shooting Star Gun Club. But not only did she promote her after the May 2021 incident, she retained her after the November 2021 incident, showing no initiative. You also learned today that when Ms. Coleman was on the stand, seeing the criminal record for the first time because she chose not to run a background check, she said, quote, "I would never have hired her." Members of the jury, that is all the information you need. If they had known about a criminal record ridden with mistakes that were careless and reckless, she said it herself. She never would have hired her. And you also heard Dr. Staub say on the witness stand that if Mrs. Cantrell could not hold the firearm and handle it correctly, she should never have taught that safety course. And that brings me to the third fact, the why. They hired Miss Cantrell because it was good for the checkbook, because it was good for money, because they needed to fill a spot that had just been left. Now, I also want to address one more thing before I end my closing. They're going to get up in a second and they're going to show you this liability form. And they're going to tell you that it shields them from any and all negligence because it says so in the form. Members of the jury, that's not how this works. I cited the case law earlier in trial. This does not bar negligence. This is just a form. We never would have gone to trial if this form meant that they are barred from all negligence. You heard Mr. Carbo say on the stand that he did not only not read the form, but he also didn't assume that they would shoot him in the leg. Now, don't let this sheet of paper shield them from any negligence claims, because the judge will tell you it's not how the law works. Find the defendant liable. Thank you.
Thank you, counsel. I'm afraid you don't have any time left for rebuttal, so we'll proceed to the defense counsel's closing argument. You may proceed.
Yes, Your Honor, before I begin, I ask that the court directs its attention to Exhibit 7, the liability.
You want the court to do that or the jury to do that?
Both, Your Honor.
Okay. You have over 20 minutes left, so I assume that'll be more than enough time for your closing.
Yes, Your Honor.
You may proceed.
Carbo knew the risks. On May 28, 2022, Justice Carbo chose to walk in to a gun store. They didn't know anything about guns. They'd never even held one. But they did know. Guns are dangerous, especially to those who use them. With this knowledge, we heard today they chose to continue the process of obtaining what they knew to be a deadly weapon. Now, members of the jury, today the plaintiff is suing my client, Shooting Star Gun Club, with negligence in their hiring and retention of their employee, Drew Cantrell. This means they took on a burden. They had to prove by a preponderance of the evidence, meaning more likely than not, 3 elements. And they failed to meet them. Now let's talk about these elements. First, Drew Cantrell was inexperienced and incompetent to be a firearms safety instructor. Today we heard on the stand that Justice Carbo, that Drew Cantrell had decades of experience with guns. They had been over 20 years of experience. Not only that, but as they were hired as a sales clerk, they gained more experience. More experience operating guns, more experience teaching about guns. They even observed others teach so they would know how to correctly do it. Members of the jury, they were not incompetent, and they were not inexperienced with guns. They knew how to safely operate them, and they knew how to safely teach others how to operate. And this was proven today. Now, the second element, Skylar Coleman knew about this inexperience or incompetence. Today, we heard from Skylar Coleman. She told you that she made sure Cantrell had experience. She made sure before hiring them, they knew about guns, because that's all they needed to be a sales clerk. While working under her control, she made sure that they learned more about them, about operating them, about teaching others about them. She made sure they were. She also made sure that they weren't incompetent. When they messed up as a safety instructor, what did she do? She reprimanded them. And those actions never. Now that third element was that Drew Cantrell's retention as an employee directly caused harm to Justice Carter. Members of the jury, this was not true. We heard from Jackie Staub, an expert in safety and firearms. We heard from Jackie Staub that she thinks the gun was the problem in today's case. We also heard that Justice Carville may have bumped into Drew Cantrell, and that could have been the fault of why Justice Carville shot. Members of the jury, there's just too many possibilities to say that the retention of Drew Cantrell was the direct cause of Justice Carbo's injury. Because today we heard that Justice Carbo knew the risks of what they were getting into, and they decided to ignore it. Now let's talk about this further. Today we brought forward an affirmative defense, assumption of risk. This means we had to prove to you that one, Justice Carbo knew the risks, and two, they proceeded anyway. Now, an affirmative defense means that even if you find that the plaintiff met their burden of proof today, if we have met ours, you still must find the Shooting Star Gun Club not liable. We've proven just that. You see, because on the stand, Justice Carbo told you, while looking at the liability form, and I quote, "I just looked through it so I could shoot." The Shooting Star Gun Club told them about the risks they were getting into. They did everything in their power to let them know the risks of what would happen in the shooting range. Justice Carbo chose to ignore. Plaintiff's expert on this. They told you about red flags. They told you about signs. Members of the jury, Justice Carbo saw the signs and the risks that they would be taking. You know what they did? They ignored them and proceeded anyway. Because on that form, and I quote, it says, "I fully am aware of the risks and hazards connected with being on the premises and participating in the gun range. I hereby elect to voluntarily participate in the gun range, knowing the activities or conditions may be hazardous to me." And then it lists the risks. These include loss, property damage, personal injury, and even death. Members of the jury, Justice Carbo did read this form. They even signed it at the bottom saying that they were aware of these risks. And after they signed that paper, the same day they walked into that gun range, putting themselves at risk. Now the plaintiff also got up here and talked about money. They talked about how Miss Coleman only hired Drew Cantrell for the money. Well, let's talk about money. Today, we heard that Carbo told you they wanted every penny from the shooting star. Members of the jury, they don't care about justice for themselves because they know what actually happened. They know they knew the risks before entering that gun range. They even heard a commercial about it and said they listened to the whole thing, and then on the stand today said that they didn't listen to the whole thing in the same period of time. Members of the jury, they wanted money from this trial today, and that's why they were so defensive. That's why they said they didn't know the risks. But we know that's not true. Because the liability form was laid in front of them. They had time to read the entire thing. Shooting Star Gun Club allowed them to know the risks of what they were getting into, tried their best to keep them safe. And they signed that form and proceeded anyway. Members of the jury, we've proven that Justice Carbo knew the risks. We've proven they proceeded in the face of those risks. This is why we ask that you find Shooting Star Gun Club not liable, because they did everything in their power to keep Justice Carbo safe. Thank you.
Thank you, counsel. Okay, we thank you so much for your presentation today. The judges are going to take a few minutes to complete our ballots. If you need a stretch or use the bathroom, feel free to do so, but just come right back because we'll be starting our comments soon.